is one of the requirements that have been made before a person may be permitted to institute a private prosecution. The rationale behind this requirement is to prevent people from abusing their right to institute a private prosecution. As the Tanzanian Court of Appeal held in Edmund, Nubegwa, and 6 others versus John Gaya, and 4 others, criminal appeal number 18 of 1999. In all applications of this kind, unless the magistrate judicially applies his mind to all the circumstances in which to grant leave for private prosecution, the danger of victimization and abuse of process is imminent. The extortion ingredient of the offense is one such factor that should not be overlooked. Turning to the instant case, the chief magistrate was aligned with the requirements of section 42, subsection 3 of the Mass Court Act. On page 6 to 7 of the ruling in Uganda, private prosecution by Yamazima Joshua and the Mukunde versus Isaac Ssemakadde, case number 913 of 2024, is stated as follows. The prima facie case under section 42 of the MCA is for court to establish as to whether the commission of an offense has been disclosed and that the complaint is not frivolous or vexatious. The complainant alleges that the alleged utterances amount to an offense under section 115, section 3 of the DCA. Section 115, section 3 of the Penal Code Act states, any person who intending to insult the modesty of a woman or girl utters any word, makes any sound or gesture, or exhibits any object, intending that word or sound shall be heard, or that the gesture or object shall be seen by that woman or girl, or intrudes upon the privacy of that woman or girl, commits a misdemeanor and is liable to imprisonment of a term of 1 year. For the first case to be made out with regard to the offense of insulting the modesty of a woman, the following ingredients must be seen to exist. 1. A person utters any word, makes any sound or gesture or exhibits any object. 2. He or she does so with intent that that word or sound shall be heard, or that the gesture or object shall be seen by that woman or girl, or intrudes upon the privacy of that woman or girl. 3. The intention to insult the modesty of any woman or girl. 4. It is the accused person who uttered the said words or who made the said sound or gesture. He further stated. The evidence before this court is of a flash disk with a video of the alleged utterances attributed to the intended accused, and the transcription of the same, of which both were annexed to the complaint. I have had the opportunity to play the video, the said video, on the flash disk. I have also read the transcription of the utterances on the said flash disk made by Uganda Broadcasting Corporation. In the said video and transcription, a male voice is heard saying, all this was like your particular carefully is then given legal addressing by this from Karamoja. I have made a case before that you have a pumpkin over DPP But some lawyers continue to pretend that she is actually DPP. And for some, they take it very seriously because they think it is an attack on womanhood. Or it is an attack on being a Kamajon. That's an absolute nonsense. She's a pumpkin. She's dead wood. She's a evil queen. She's a careless, shameless, careless. She's to go in the nest of our criminal justice. The male voice to the above court was trying to indict prosecutions. Uganda has one DPP, Honorable Justice Jane Francis Aboto, who is a woman. And she comes from California. It is most likely that she is the person referred to in the above video. In the said video, the male voice is heard referring to the DPP, a woman, as a vagina from California, a pumpkin, deadwood. In their primary meaning, the above words are offensive, and if directed to a woman, they amount to insulting her modesty. It follows therefore that whoever made such utterances at a public gathering in the presence of media intended that Honorable Justice Jane Francis Aboto would hear the same utterances. Anyone who refers to a woman by her private body parts intends to insult her modesty. Anyone who refers to a woman as from Karamoja, Deadwood, at a public gathering, well aware that there is media presence, know that the said woman will definitely hear those words against her. The intention is most likely to insult her modesty. The person in the video has been identified as Isaac Kimaze Ssemakadde, the president of Uganda Law Society. When his advocates appeared in court on 4th December 2024, they did not dispute the allegation that was apparent in the video. The argument was that Honorable Justice Jane Francis Aboto had not complained, yet this case is victim-centered. The victim, the evidence of record is as alluded to in the Chief Magistrate Court ruling, indicate that firstly, the necessary elements of the offense of insulting the modesty of a woman were established. Below is the breakdown of how each ingredient is satisfied. Utterance of words, sounds, gestures, or expression of objects. The example that a person uttered derogatory terms and phrases directed to a woman in a video recording. To intend for the words or sound to be heard. There is every evidence that the remarks were made at a public gathering with media present. The setting and presence of media indicate a clear intent to broadcast those statements beyond a private conversation. The strategic choice to articulate the remarks in a forum where they would be recorded and disseminated underscores the likelihood that they are told so to express his views and ensure they reach the victim's ears. The intention to insult modesty. When given their ordinary meaning, the language used is offensive and demeaning and serves no constructive purpose other than to inflict emotional found and deliberate in a public setting, wherever they intended. 4. Choose as the originator of the remarks. It has been established that Ssemakadde is the individual making the remarks in the media, and his advocates do not dispute this identification in court. The Chief Marshal accurately concluded that a prima facie case for the alleged offense was established as all essential elements were evident. I will now deal with the issue of reasonable and probable cause. Section 42, Section 3 of the MCA provides that a person other than a public prosecutor or a police officer who has reasonable and probable cause to believe that an offense has been committed by any person may make a complaint of the alleged offense to a magistrate and has jurisdiction to try or inquire into the alleged offense, or within the local limits of whose jurisdiction the accused person is alleged to reside or be. Every such complaint may be made orally or in writing, signed by the complainant, but if made orally, shall be reduced into writing by the magistrate, and when so reduced, shall be signed by the complainant. This section empowers individuals, private citizens, to prosecute crimes they believe have occurred. It specifies that any person, except for public prosecutors or police officers, who believes an offense has occurred, has the right to make a complaint. The individual, however, must have reasonable and probable cause for believing that an offense has been committed. It does not matter whether an individual is the victim or not. All that is the same individual is required to have legitimate reasons or evidence.
Normally, securing evidence, whether that is the ruling for the stop execution or the main application, which is revision. Number 30 is the application for stop execution.
I'm waiting, as I said at the beginning. Were you not hearing? You will check the report after. Don't disturb the report. This section empowers an individual, private prosecutor, private citizen to prosecute crimes they believe have occurred. It specifies that any person, except for public prosecutors or police officers, who believes an offense has occurred, has the right to make a complaint. The individual, however, must have reasonable and probable cause for believing that an offense has been committed. It does not matter whether an individual is the victim or not, or that the said individual is required to have are legitimate reasons or evidence to suspect that a crime has taken place. The operating phrase in the above section is reasonable and probable cause. In Aminam TV versus Ramadan Kiwe, probable and reasonable cause was defined as quoted, an honest belief in the guilt of the accused, based on a full conviction, founded upon reasonable grounds of the existing state of circumstances, which, assuming them to be true, would reasonably lead an ordinary, prudent, and cautious man, placed in the position of the accuser, to the conclusion that the person charged was probably guilty of the offense imputed. The phrase reasonable and probable cause means the individuals should have legitimate reasons or evidence to suspect that the crime has taken place. This requires more than mere suspicion. Some level of evidence or support for the belief is necessary. In the instant case, the private prosecutors presented evidence alongside their complaint, specifically the flash drive containing a recording of the alleged utterances contravening section 115, Section 3 of the Penal Code Act, and a transcription from the Ghana Broadcasting Corporation. The Chief Magistrate judiciously considered the statement under oath and consultation with the ward administrator, and found that the complainant had made the threshold of a reasonable and probable cause before ordering the prosecution. Round 10 and 11. The Chief Magistrate wrongly found the response complaint was not vexatious and frivolous. He argued in holding that the respondent's complaint was not an abuse of court process. Section 42, Section 5 of the Magistrate Act provides, after satisfying himself or herself that firstly, the commission of an offense has been disclosed, and that the complaint is not frivolous or vexatious. Under this ground, the court is more interested in the phrase, and the complaint is not frivolous and vexatious. This part of the section is that the complaint should have merit and not be based on unsupported accusations or intended merely to cause trouble. In his affidavit supporting this application, the applicant asserts that the respondents have initiated several lawsuits against him in bad faith, clearly misusing the court process, and in blatant abuse of court process, seeking to further harass him by commencing a baseless private prosecution. The fact that a private prosecutor is bringing proceedings or civil proceedings are concurrent or made an option and irrelevant considerations, save where improper motive is concerned. For an accused in private prosecutions to raise the issue of the improper motive of the prosecution or prosecutor, they should ordinarily be able to establish that 1. The private prosecutor is pursuing a personal vendetta against them. If instituted, the civil suits are in a way related to the criminal one. 3. The prosecution is purely out to achieve financial redress rather than a means to obtain punishment for criminality. In the instant case, I find no evidence on record demonstrating that the private prosecutors have personal vendetta against the applicant. I also find that the applicant has not proven that his prosecution is solely motivated by the desire for financial redress rather than to obtain punishment for criminality. Through his pleadings, I find that the respondents have filed 2 civil matters. However, although these 2 matters are civil, they are not connected to the criminal matter filed by the respondents. These civil matters concern the expulsion of the Attorney General and Solicitor General from Uganda U.S. Counsel via Order RNB number 1 of 2024. The current criminal matter involves insulting the modesty of a woman. The applicant claims that the matters were withdrawn but provides no evidence. If the 2 matters are still in court, the civil court will determine whether the response had the necessary locus standi to file those matters. In doing so, the issue of whether the rigorously abused the court process will be adequately addressed. If they were withdrawn, as suggested by the applicant, he is welcome to seek damages in the civil court for malicious prosecution. What this court will not do is to infer abuse of court processes without concrete evidence. Round 2. The Chief Magistrate improperly failed to dismiss a denied complaint on oath by the intending private prosecutors. The scenario that gave rise to this ground can be likened to a witness giving evidence in case being cross-examined, seeming to contradict themselves and offering clarification during re-examination. Paragraph 5 of the affidavit in support of Vice Freedom is application number 87 of 2024 states, I know that on 22nd November 2024, a cantankerous couple of mischievous advocates, Yamazima Joshua and Tole Tumukunde, filed a complaint on oath seeking summons for my appearance to plead to a proposed charge of insulting the modesty of a woman, to wit, M.S. Jane Francis Abodo of Karamoja. Under Section 115, Subsection 3 of the Penal Code Act. In paragraph 7 of the affidavit in reply, Joshua Yamazima declared what seemed like a denial of the complaint on oath, if read in isolation of the entire affidavit. The deposition stated that the contents of paragraph 5 to 26 of the applicant's affidavit are denied in total, and the applicant shall be put to strict proof thereof. However, if the entire affidavit is read, it becomes clear that the complaint on oath was not denied. Paragraph 9 states, I know the complaint on oath in KLA 00CRCO 0913 2024 is competently before the court, having complied with all the preliminary requirements. And of course, I find that Joshua Yamazima did not deny his complaint on oath, despite what might appear to be a denial when looked at in isolation from the entire affidavit. In paragraph 7 of the affidavit in reply, Joshua states that he denies the contents of the applicant's affidavit, including the complaint in total, which would be interpreted as denying the complaint. However, when taken in the context of the entire affidavit, including paragraph 9, it becomes clear that he acknowledges the existence of the complaint on oath. In explicitly saying, I know the complaint on oath in KLA that's 00 that's CR that's CO that's 0913 that's 2024. The respondent is, in essence, indicating that they know the particulars of the sworn complaint related to the case number allocated to the matter involving legal allegations or claims. In saying, is competently before court, the respondent admits that the complaint has been adequately filed according to legal procedures and is under the court's jurisdiction. So, while he may deny the specific allegations or claims outlined in the application, it does not deny that the complaint exists and is legally in the court system. Round 6. The Chief Magistrate disregarded Section 6, Subsection 2A, 7, Subsection 1, and 2 and 4 of the Electronic Transactions Act in considering the response video evidence. For ease of reference, I will reproduce the law. Section 6, Section 2A, Section 7, Section 1, 2, and 4 of the Electronic Transactions Act, Cap 99, provides without going into the merits of the case, ensure that electronic communication can be organized and evaluated in judicial proceedings is essential. So, when does the electronic evidence become admissible? During investigations or trial? Electronic evidence is admissible when it is authenticated and meets the rules of evidence, typically at the trial stage, during the preliminary phase of a private court, private prosecution, evidence is used to establish a prima facie case, meaning at this stage, the focus is on whether sufficient evidence exists to proceed rather than effectuating the conviction. In the current case, since the trial had not commenced, the chief magistrate was not required to adhere to the admissibility criteria for electronic evidence. His only obligation under section 42, section 5 of the Magistrate Act was to determine if the available evidence could raise a presumption of fact, which he successfully fulfilled. Ground 8. The chief magistrate did not consider the context, symbolism, and constitutional protections of the words in question, thereby occasioning a miscarriage of justice. I will first deal with the issue of failure to consider the context and symbolism of the words in question. The first, often considered the primary rule of interpretation in literal rule, is the literal rule. Under this rule, words are interpreted based on their plain, ordinary meaning, without developing into other excesses like context, symbolism, intent, or purpose. When using this rule, the court's only role is to ascertain the meaning of the words in their common, everyday sense, rather than with specialized or technical meanings. In the instant case, the trial magistrate followed the first rule of interpretation, as seen on page 7 of his ruling, via criminal case number 913 of 2024. I quote, in the same video, the male voice is heard referring to the DPP, a woman, as a vagina from Karamoja, a pumpkin, dead wood, a dimwit. In their primary meaning, the above words are offensive, and if directed to a woman, they amount to insulting her modesty. In my view, I find that even an ordinary bystander, having given the words in question their ordinary meaning, would have come to the same conclusion, that the words were offensive. If the applicant wanted to benefit from the other two rules of interpretation, the golden rule and mischief rule, he ought to himself to appear before the court when summoned, and if put on a defense, explain the context and symbolism of the words in question. Then the court would have something to consider. From an outsider's perspective, the applicant wants to use revision to circumvent the procedure. I will now turn to the issue of failure to consider the constitutional protections of the words. Article 29, Clause 1A of the Constitution guarantees freedom of speech and expression. This right is fundamental to the foundation of a democratic society, enabling individuals to engage in open discussions, challenge authority, and promote government accountability. It is a crucial element of a free and just society, fostering informed choices, enhancing transparency, and allowing individuals to express their diverse opinions. While freedom of expression is a core aspect of Ugandan society, it is not without its limitations and restrictions, particularly regarding national security, public order, and the rights of others. See Article 43 of the Constitution. Several laws in Uganda regulate the landscape and activities related to freedom of speech. Therefore, speakers must understand the boundaries set by law before engaging in any speech. Of specific interest in this case Article 43, 1 and 2, Part C of the Constitution. Article 24 of the Constitution. Section 115, Subsection 3 of the Penal Code Act. Article 43 is reproduced, Article 24 is reproduced, and Section 115, Subsection 3 is reproduced again here by the land judge. When read together, the above provisions of the law show that while individuals in Uganda are entitled to speak freely, the prevailing legal environment indicates that such freedom exists within a framework of caution and compliance with the complex web of laws meant to protect various interests. In this particular case, within the context of the ordinary meaning, dehumanizing words which serve no constructive purpose other than to inflict emotional harm and regret were allegedly said in a public setting with media present. The words were directed to a woman. The remarks, having been allegedly said to a public gathering, at a public gathering with media present, indicate a clear intent to have the statement recorded and disseminated with a likelihood of reaching the victim's ears. Considering this, the applicant could, on the face of it, be said to have committed a misdemeanor under Section 115, Section 3 of the Penal Code Act. Contravened Article 43 of the Constitution by violating the fundamental human right of a woman he is alleged to have consulted that are also protected under Article 24 of the Constitution. For the court to regard the said words as protected, it must evaluate whether they fit within the acceptable and demonstrably justifiable category as outlined in Article 43, 2C. Determine whether words are constitutionally protected is inherently contextual. The court cannot indiscriminately classify any words or particularly those deemed offensive as constitutionally protected without proper context. The applicant has failed to provide this necessary context despite being called upon. Consequently, he cannot fault the Chief Magistrate for not recognizing them as constitutionally protected. Counsel, my duty is to pronounce the ruling, and
Your Worship, we intend to arrest the ruling because it has several
before the judge, my duty is to pronounce it, and I pronounce it. Don't disturb.
Your Worship, I'm not disturbing you.
Round 3. The Chief Magistrate in law by denying the applicant's request to cross-examine the Amazima on his affidavit in reply. Get to know that this is, I'm just a registrar assigned to perform a particular duty, and it must be done. It's my duty. Once I fail, I have failed myself, and I will not sit as a registrar. So, abide by that. The rest will continue with the trial judge, okay? The right to cross-examine witnesses, including a private prosecutor, is a fundamental aspect of a fair trial, ensuring that the accused can challenge the evidence presented against them. However, under Section 1 of the Evidence Act, cross-examination of an affidavit in reply is at the discretion of the court. Section 1 of the Evidence Act provides that this act shall apply to all judicial proceedings in or before the Supreme Court, the Court of Appeal, the High Court, and all courts established under the Master Court Act, but not to affidavits presented to any court or officer, nor proceedings before an arbitrator. The Act is intended to govern the proceedings in specified courts while explicitly excluding certain legal documents, affidavits, and alternative dispute resolution processes, arbitration. By virtue of this, the court may exercise its discretion to allow cross-examination depending on particular factors of each case. Some of the things the court can consider before exercising its discretion include the following. 1, the nature of the case. 2, whether consideration will duly delay the trial or facilitate expeditious disposal. 3, whether the deponent of the affidavit contains facts that are in issue or conflicting evidence. 4, if prosecution will assist in resolving the issue before the court. In the instant case, the response are said to have denied their complaint on oath. The Chief Magistrate in his ruling, by instance application number 87 of 2024, found that once the 10 paragraphs of the said affidavit once the 10 paragraphs of the said affidavit are read together, Joseph Jamazima cannot be found to have denied filing the complaint. Herein, I have agreed with this finding and the subheading ground 2. In my view, this examination would only unduly delay the trial and would not have facilitated the expeditious disposal of the matter. It, therefore, did not warrant the court to exercise its discretion. Ground 4. The Chief Magistrate wrongly concluded that there was no breach of the duty of candor by the respondent. Paragraph 9 of the applicant's motion, by criminal section number 87 of 2024, says that the respondent did not make frank and full disclosure to the court and the investigative and prosecutorial authorities. Additionally, paragraph 15 of the affidavit in support of by criminal section number 87 of 2024, the applicant affirmed that the cantankerous couple unjustifiably deprived me of the opportunity to confront the alleged victim on the ingredients of the proposed offense before an independent investigator, thereby violating my constitutional right to a fair pre-trial investigation. I recognize that the legal framework for private prosecution is unclear and well developed. This may taint an actual person's right to a fair hearing and Article 44, Section Part 4 of the Constitution. Part C. It may also hinder a prosecutor's right to successfully prosecute a clever accused person who exploits these loopholes to their advantage through unnecessary endless objections. In light of this, I find this issue deserving of revision. This would enable the court to interrogate the various problems arising, including disclosures in private prosecution. When are they made? What can be disclosed? And to whom are they made? 2. The right of prospective accused person in private prosecutions. 3. The roles and duties of the private prosecutor. 4. The role of the victim. Ground 12. The Chief Magistrate improperly declined to recuse himself from the proceedings. The applicant contends that the Chief Magistrate should have recused himself from the trial. The record shows that the Chief Magistrate considered the request to step down and dismissed it for lack of merit. In light of all the above, except for ground 4, which touches on the right to a fair hearing, I find that the many grounds for revision fronted by the applicant do not raise legitimate issues with a reasonable chance of success if brought to a full hearing. By virtue of ground 4, the applicant has established my first case whether the applicant will suffer irreparable damage if the application is not granted. The applicant contests that he will suffer irreparable harm and prejudice by undergoing a trial that is preface reshaped by fundamental flaws and irregularities. The applicant further asserts that the circumstances have exposed him to adverse publicity, damaging his status, profession, and livelihood, and threats of arrest, detention, conviction, and sentencing on a charge he maintains is unfounded, illegal, defective, and unsustainable. Conversely, the respondent argues that the applicant has failed to demonstrate that he will suffer any loss or injury and cannot be compensated through monetary damages, nor has he shown that such harm is difficult to quantify. This court is in doubt as to whether or not the law shall be irreparable. Considering this, I find that the applicant has failed to prove this ground. Whether the balance of convenience tilts in favor of the application being granted. This fundamental principle is only considered if the court is in doubt of both or any of the first two requirements. Having found that the applicant has a prima facie case, but the court is in doubt as to whether or not they will suffer irreparable loss, the balance of convenience must be considered. To achieve this, I will weigh the potential inconvenience to the applicants against those of harm to the respondents if the stay is granted. Firstly, the applicant argues that proceedings with the lower court's prosecution without a stay would lead to a situation where if the revision application is ultimately upheld, the applicant would be left with a position where their rights and liberty have been impacted unnecessarily. The argument emphasizes preserving the status quo until the revision application is resolved. On the other hand, the respondent asserts that a stay would impede their legal rights and hinder the judicial system's integrity. I acknowledge that the ability to pursue legal remedies is a cornerstone of justice, and an obstruction could set a precedent that undermines the efficiency of the legal process. However, the court must balance the rights of the victim and the accused person so that none should be sacrificed at the altar of justice. The victim and the accused deserve justice. All must have their day in court without unjust roadblocks. Secondly, the applicant highlights the importance of safeguarding personal liberty, which is a fundamental principle of law. By granting a stay, the court protects the applicant's rights, ensuring that any adverse actions taken by the lower court are revisited and assessed for validity. On the other hand, the respondents emphasize that halting proceedings will have serious ramifications for the proper function of the justice system, potentially affecting public confidence in the rule of law. Third and last, the applicant argues that allowing the lower court to proceed could result in irreparable harm to him if the findings were annulled later. A stay would mitigate this risk by halting proceedings while revision is promptly conducted. The applicant is basically arguing that if the lower court continues with these proceedings and makes findings that are later overturned, it could lead to significant and irreversible damage to him. Therefore, he believes that granting a stay is necessary to prevent this potential harm while a review of the case is conducted. On the other hand, the respondents argue that if the stay were conducted, they would subsequently suffer a loss of their rights to prosecute. They may not be able to recover damages sufficient to compensate for the full extent of their loss if they not stay of proceedings pending revision application were found to be unwarranted. Unlike the malicious prosecution remedy available to the applicant, the respondents argue that granting the stay would potentially harm their rights to pursue prosecution, and that they might not be able to fully recover damages for their losses if the stay is deemed unnecessary. The situation contrasts with the applicant, who can seek a remedy for malicious prosecution. In the scenario presented, the balance of convenience leans towards the applicant for several reasons, despite the valid concerns raised by the respondents. The reasons in favor of granting include: 1. Preservation of the status quo. The applicant emphasizes maintaining the status quo until the revision application is resolved. This argument underscores the need to prevent the potential violation of the applicant's right to liberty that could arise from continuing the lower court prosecution. 2. Judicial integrity and the rights of the respondents. While the response raised important points about the potential injuries to their legal rights and the judicial process, these concerns are primarily about the implications of delays and the judicial system's efficiency. However, the more pressing issue is the protection of individual rights, especially when those rights may be jeopardized. The response claims of harm do not carry the same immediacy or risk of damage compared to those of the applicant concerned. In the interest of justice, I find it justifiable to grant a stay to safeguard the applicant's right to liberty while the revision is underway. This would ensure a fair process for both parties without the threat of serious consequences. Decision. The application is allowed for the following reasons. The applicant has established a prima facie case. 2. Balance of convenience is in favor of the application being granted. Orders. 1. The Chief Magistrate of Uganda Road is directed to stay proceedings in Uganda. Private prosecution by Yamazima, Joshua, and Tony Kikonde versus Isaac Kimaze Ssemakadde. Uganda Road Chief Magistrate case number 913 of 2024. Pending determination of Isaac Kimaze Ssemakadde versus Uganda. Private prosecution by Yamazima, Joshua, and Tony Kikonde. Criminal revision case number 002 of 2025. The parties are directed to file submissions in the criminal revision case number 2 of 2025 to expedite the revision. The applicant must file his submission by 23rd of April, year 2025, while the response must file their reply by 2nd May 2025, and a rejoinder must be filed by 7th May 2025. The court will issue its ruling or not. Signed, Gardenia, Paul, Woliva, Judge, 10th April 2025.
Everywhere! Thanks, Your Honor.
Around B.
Any other matter? Any other matter has like question you see your paper? None. That's what I say. You can go and see copies, they are already available.
It's typed.
Everywhere! Around B.
Everywhere.
Everywhere!
So, counsel, you said you are against the national judgment. Counsel, exactly what's happened?
No, Sajja doesn't have to.
Let me come. Guys. Okay, we are going to get the interviews from these counsels who are in charge of this. Yeah. Okay, I know. Let me hope the president is on. I'm sure he's on. Bani? Bani.
No, kyekisoose kukanga olaba omusajja akugamba kati olabye omusajja kyagamba
Yeah, how about you?
Do you need him to say so? Can you execute? Do you need him to say so? Let him appoint someone. Anyway. R&B everywhere. Everywhere R&B. Man, you know.
Muje tukoleko interviews. Muje tukoleleni once interviews. We have to work from down. Tagenze eno. Tugende wansi wano waliwo omusango ogenda mu kooti. Tugende wansi. We slope down. Eri omusango ogenda mu maaso. Kale bannange Isaac Ssemakadde mujjukira bulungi wano ku Extreme Media UB fo abaamuleeta fo abaatambula naye wano ku Extreme Media UB era ffe tuli wamu naye. We are not lawyers naye we believe in him. Alina message jawa abantu nga amazima. It's true, so touching. That is counsel Isaac Ssemakadde. We need to get speak to these people bakansa bali mu musango guno batubuulire kiki ekigenda mu maaso. Tukyali court. All right. Alright, for more information you can contact me on those numbers wow, in case you need to know anything about Kali. We are live on Extreme Media UB and tukyali ku High Court. Tuli ku High Court. Twagala batubuulire ekifaananyi ono kibi. Tulabayo wano kifaananyi nga kino bonna. Ayagala okutegeera ebisingawo wano ku Extreme Media UB zezo namba z'empini zewaawo ziri waggulu. Oyagala more information, ayagala kulangana, if you want to advertise with us, you call on those contacts. As you can see, bantu bambadde obutishaati nga buliko RNB.
Of course tumwenyaamu ate ensonga eri serious by the way teri kusaka tulina omwenya kubanga omusajja asomye gundi nange Ssemakadde ate aleese kale Ssemakadde alina kaase yalinze wano naye banaye ekigambo kiri R&B everywhere R&B. Yes Professor jabadde ngambye afuna ruli bamugambe
Isaac una soka mugambe gundi asoka aveyo Isaac president
Hey, okay.
For the media briefing.
We are waiting for the councils abali mu kintu kino abali mu musango guno batubuulire kooti egambye eki decisions ziri zitya. Ekiganye bannange
bayita gundi Professor Mukiibi gwe bayita yajja Professor Mukiibi.
Professor Mukiibi ate abadde agenze
bamugambye akomewo abireko yabadde bamukubye. Remember here a junior Yeah.
Yes, ogendeyo olabe.
Eri.
But it is okay. Kale tuli wano tuli mu kulindako ba lawyers nga mu bano batugambye nti mulimu Professor Mukiibi agenda kubanga atubriefinga ffe bannamawulire. He will tell us kooti esazeewo ki olunaku olwaleero. Nyongera okubajjukiza nti ebintu bino biruddewoko ebintu bya Ssemakadde naye katusooke tufune interviews. Let's get briefed. Come this side. Eneno banange tukole
the public is not confused to what the Supreme Court. So I avoid public confusion.
President.
Ngambi agenda
Bagala shinzi tuzireko tuzite.
Kyemwagala enaku zino radical new bar RNB.
I'm going to ask also, I don't know if it is new.
Very new.
Yes.
Everywhere R&B everywhere R&B everywhere. That's the anthem.
Deborah had some issues. I'm going to give her the pictures. Yeah.
Maybe you can pose the questions to us and then we'll respond.
Counsel, mugenda tuwulirako okusinziira ruling bwebadde, first in English, then in Buganda.
Yes, but also we have two aspects.
Yes.
We have Professor Mukiibi,
It is
who is also standing for
the president.
the representation of the Judicial Service Commission.
it's okay.
So he also gives an independent voice
It is okay.
to what he sees as happening, and more importantly, because he will be the voice of the wider society and generally the public.
We shall get his.
So his views are also very, very important.
So whom should we start with?
We are going to start with Counsel Derrick. Counsel Derrick,
I can't speak after him. He's my senior. He taught me, so I can't speak
let
after
him come here.
I can speak after you.
Yeah,
Now,
try
yes,
to
that
be
is
a
not
little
very
bit
balanced.
audible.
Sati of it is very balanced. I would rather choose to be the same.
Okay.
Do you?
So tusandike na which version? English, Uganda?
English. Yes.
Balabe bulungi.
Let me not start.
Make sure you balance.
Soko balancing wali soko sembere wali ba.
We remove the shades.
No one.
So you let us know when to start.
English.
First English, then.
Okay, counsel. You can easily tell us what transpired in the court today.
All right, what has brought us today here was to receive a ruling on an application for stay pending determination of a revision application, and that matter arises from the private prosecution case which was filed before the Chief Magistrate Court of Kampala, Uganda Road. And as you are aware, the Chief Magistrate, in his view, found a prima facie case against the respondent, who is the President, Commander Officer Isaac Ssemakadde, and also went ahead to issue criminal summons and subsequently issued an arrest warrant disguised as international arrest warrant against the President. So the President, through his lawyers, GEM advocates, filed an application for revision in High Court and also filed a stay pending determination of a revision application. So today's proceedings were to deliver that ruling, and actually the ruling has been delivered. And in summary, the court has been convinced that the applicant, who is President Isaac Ssemakadde, has satisfied the prima facie case warranting court issuing a grant of stay of proceedings before the Chief Magistrate Court of Uganda Road. And the court has also gone ahead and give schedules for filing submissions in the main revision application. So apparently, court is convinced that the grounds in the revision application raises some prima facie case in favor of the applicant, and has also gone ahead to weigh between liberty of the applicant vis-a-vis that of the respondent. And the court's view is that the liberty of the applicant outweighs that of the respondent, and has gone ahead to grant it all long, about 40 pages, but that is the summary of the gist that court has pronounced. And we think this is a right direction in view of the R&B's Vision 2060. One of it is independence of the legal profession, and also promoting the right to insult, giving positive criticism to judicial decisions and judicial actions and those in power. So we think that this is the right direction, and if court is satisfied that despite of the utterances, whatever way they are calling them, court has found the prima facie case warranting staying until the main revision is determined.
Yes, Professor for Mutwawansi, does it mean that, wait a minute, does it mean that the international, Interpol, whatever, all those ones are on board?
Automatically, they have been stayed. Meaning, you cannot now execute them. And executing means you would proceed to arrest. Now you cannot arrest because they have been stayed until the revision is determined. And the court has given schedules and said the ruling on revision will be notice.
Then in the Luganda version.
Perspective.
No. Let him first. Let him first. Kali.
You give that view from someone. How do you see these things in terms of the way you want to represent us? So, from the grand scheme of things, what does it mean?
Thank you.
Okay.
One, I must say that this has been a serious battle. As you may be aware, we have been pressing so much to get a ruling. So many events have been happening as far as this matter is concerned. It started with finding a prima facie case, very fast issuing criminal summons, very fast issuing arrest warrant. And when these applications were filed, there was a bit of delay to dispose them of. We have fought a battle, we have pressed, we have written, persons have written, demanding for disposal of these applications. I'm very glad that the court has responded. and again responded positively in favor of the applicant. That gives us courage and confidence that the fight continues, and this is what we want. Decisions that can balance rights of all parties, such that we have confidence in the judicial system. And that is what we are fighting for as candidates, as myself a candidate for Judicial Service Commission. We need to have judges independently. We need to have them dispose their decisions independently without any interference. Even an ordinary person, even a member of the bar, anybody can win a case based on merit without any influence.
Okay, give us Uganda.
Ekituleese wano olwaleero tubadde tuzze okufuna ensalawo ya kkooti okusaba Pulezidenti wa Uganda Law Society Isaac Kimaze Ssemakadde. Ensonga zino ezivunaanibwa Pulezidenti zatandikira mu kkooti eya Buganda Road nga waliwo abaawaaba omusongo bannamateeka babiri ku lwabwe nga teguvudde mu gavumenti nga bwe kitera okuba. Ne bawaaba nga bagamba ebigambo Pulezidenti byakozesa ku function emu bivoola ekitiibwa ky'omukyala oba ekyabakyala. Ne bateekayo okwemulugunya okwo ne basaba kkooti ekkirize nti alina omusango asobole okujja yeewozeeko. Kkooti ya Buganda Road yakkiriziganya nabo negamba nti Pulezidenti alina okujja yeewozeeko. Kkooti negenda mu maaso nemuweereza empapula ezimuyita okujja okwewozaako, ate era negenda mu maaso neteekawo ekiwandiiko ekiragira okumukwata singa aba tazze wonna waali. Pulezidenti n'agenda neyekubira enduulu mu kkooti enkulu oba high court ng'agamba nti enkwata kkooti ento gye yakwatamu ensonga ezo teyali ntuufu mu mateeka, era nga yeemulugunya kkooti enkulu esobole okutunuulira fayiro eyo yeekeeneenye ekole n'okusalawo oba omulamuzi wa kkooti ento kye yakola kyali kituufu oba kikyamu. Era n'ateekamu okusaba okulala nti ng'ekyo kkooti tennakikola esooke eyimirize ebiragiro ebikolebwa omulamuzi wa kkooti ento okutuusa okwemulugunya kuli okukulu nga kusaliddwawo. Ekyo kye kituzeeko olwaleero, era kkooti ensala ekituwadde, era ensala kkooti ekkiriziganyiza n'eyeemulugunya Pulezidenti Isaac Ssemakadde n'egamba nti bwetunuulidde ensonga zonna zonna eraba nga okwemulugunya kwe kulimu eggumba, era nekkiriza nti tesobola kuleka biragiro bya kkooti nto kugenda mu maaso okwemulugunya kwe tennabakola ki kuuli. Nesalawo negamba ebiragiro bya kkooti ento byonna ebiyimiriza okutuuka ensala okwemulugunya okukulu nga kuvuddewo. Kitegeeza ki? Nti olwa Pulezidenti Ssemakadde takyasobola kukwatibwa ku kiwandiiko ekyo ekyaweebwa kkooti ki ento kiyimiriziddwa. Ate ne kkooti mu nsala yayo egenze maaso neeragira omulamuzi wa kkooti ento obutaddamu kubaako kyakola mu musango okutuusa nga kkooti eno ekoze eki emaliriza okwemulugunya okwateekebwayo okukulu kwe tuyise revision. N'olwekyo kitegeeza nti radical new bar oba kino ekisinde ekiriwo ekikulembera Pulezidenti Isaac Ssemakadde ekyabalooya kirwanirira ensonga ezikwata ne eddembe lya munnamateeka, okwogera, okwemulugunya n'okwogera ensonga enkyamu zonna ezikolebwa abali mu buyinza oba bakitongole ekiramuzi oba kitongole ki awatali kubeekwekera okubategeeza ekibakwatako n'okutereza engeri gye bakolamu ensonga zaabwe. N'olwekyo kkooti okugamba nti ensonga ze zirimu eggumba kiraga nti kkooti ekkiririza mu enkola ey'eddembe ly'obwannamateeka, era bemu ku biruubirira era kisinde kino ekiyitibwa radical new bar mu mwaka 2006 okubeera nga eddembe ly'abannamateeka lituukirizibwa fule. Ate ekyo tekigenda kulinda 2006, kitandika leero, kyatandise eggulo, so kino okugenda muki mu maaso. N'olwekyo ensonga zino tukyagenda nazo mu maaso, ate era kyongera okutulaga nti wakyaliwo abalamuzi abasobola okuyimirira ku bigere byabwe ne bakola ensalawo nga teri abanyigiriza, teri abatiisatiisizza, ne bateekawo obwenkanya. Ffenna kye tulwanirira kusinde kino.
Kino kitegeeza tugambe nti sawa zino Pulezidenti wa ELS ali free okutambula bonna, kiti ekibaluwa kivuddewo
ku musango guno, ekibikwata ku musango guno ali free okuleka nga omuvunaanidde emisango miki mirala nga gyofunye ebiragiro, naye ku guno ogutuleese ali free olwaleero.
Professor.
So Derek, so
Oh, Professor, yes.
Counsel
Derek.
ndowooza osobola otandika ne date ezo oba n'eyo layini ya anga eyo nga bw'oyongerezaako.
Ngaffe temutubuuzizza tulowooza ku ruling ya leero tuwulira tutya
kyetwagala era kyetubadde tusaba otubuulireko kanso.
Sooke lw'oyagala
byonna olina comfortable.
Sooke n'ekizibu nze ku kyangu.
Ekizibu kyekirimu.
Naye byonna byangu.
Today we came to receive the ruling in an application for stop execution filed by the Uganda Law Society President Isaac K. Ssemakadde. It has taken time for court to deliver its ruling. Actually, initially we thought the ruling would be delivered on ECMIS, which is the judiciary online platform for filing cases. That explains why we are not dressed in suits. However, we were informed that the ruling would be delivered physically, and we appeared in court today, and we prayed that court sees us, and indeed court allows to see and hear us. We have mixed feelings about this ruling. We are very happy, extremely happy, but we are also extremely sad. If you may recall, we asked the trial court at Uganda Road to stay criminal proceedings until the High Court investigates the matter. It should not take a High Court judge to make a decision that stay criminal proceedings until I hear their complaints regarding how you are handling the case. That is the sad bit. We apologize to Ugandans that we've taken up your time and space on this application. It should not have been the High Court judge to make this decision. It should have been a simple decision to make, as the case we put it in the lower court. I can only imagine how much time the judge has spent and how many cases he has had to set aside to write 40 pages only to state that Uganda Road Court, stop what you're doing until I hear what President Isaac Ssemakadde has to say. I can only imagine how many bail applications have had to be stayed for the judge to write 40 pages on just staying criminal proceedings against President Isaac Ssemakadde. I can only imagine how many Ugandans have had to suffer when the judge has had to sit down to write 40 pages and not hear their cases, not to hear evidence. We have victims of crimes that have suffered and endured the delays. We've had accused persons who have had to go back and wait for their cases to be heard. I pray and hope that it should not happen again, that whenever a High Court is investigating and supervising the way magistrates are doing their work, they should extend the courtesy to just stay whatever they're doing so that the High Court makes the investigations. That is on the sad note. But we're also extremely happy that the judge has examined the issues and boldly made a statement that Mr. Isaac Ssemakadde, the president of the Uganda Society, raises very important issues, and that the balance of convenience, his right to personal liberty, outweighs the right of another Ugandan to complain on behalf of someone else who has never come to court to complain. And court has been pleased and bold enough to stay the criminal proceedings at Uganda Road Court. Whereas we apologize to Ugandans for the time it has taken for court to do this, and the resources. A High Court judge is a very busy judge, extremely busy. He handles serious cases, capital offenses that attract a death penalty. He should be involved in serious cases, not hearing applications for stay. Wait to hear an arrest warrant until the High Court determines whether what you're doing is right or wrong. That should be a simple thing. It shouldn't require a High Court judge. But unfortunately, it has taken up resources and time. Eventually, our arguments have been upheld at a higher level now President Isaac Ssemakadde has set a precedent on what should happen whenever a lower court, a trial court, a magistrate is handling a case when there is a revision application. Ssemakadde Isaac, the President of Royal Society's Senior Counsel, has now settled the law. He has settled the law. Wherever he is, the law in Uganda has been set. The court has given us timelines for filing submissions to argue now the main application on the proceedings before the lower court, determining whether they were lawful, legal, correct, and all issues involved. So we are supposed to file our submissions on the 23rd of April 2025. Mr. Joshua Byamazima and Tony Tumukunde will file their submissions by the 2nd of May 2025, and we'll file our final submissions on the 7th of May 2025. Again, the ruling will be on notice.
Uganda Council.
Leero tubadde tusuubira nti nno ensalawo ya kkooti ku oba kkooti ento eya Buganda Road eyimirize ebyekola oba nedda, tubadde tusuubira nti binaabeera ku mutimbagano nga bayita ku nkola ya ECMES jirisha bwe gye yateekawo, naye batugambye nti tugenda kubeera mu kkooti live. Yensonga lwaki tubadde twambadde nga tuli mu masuuti aga bulijjo, nga tuli mu t-shirt, tuyimirira wamu ne client waffe President Isaac Ssemakadde. Tuli basanyufu ate tuli banakuwavu nnyo ebigenze mu maaso leero. Tuli banyiikaavu nti kibadde kyetaagisa omulamuzi owa kkooti enkulu okutuula awandiike pages 40 okusalawo ensonga oba kkooti ento esooka erindeko paka nga kkooti enkulu emaze okutunula mu nsonga za Isaac Ssemakadde oba nedda. Twali mu kkooti ento twakitegeeza nti tekyetaagisa mulamuzi wa kkooti enkulu wa decision eyo. Lwaki? Kimala obudde bungi, ate bannayuganda abalala tubajjako omukisa okuliiza emisango gyabwe. Omulamuzi wa kkooti enkulu mulamuzi abeera bize nnyo, alina wuliriza misango gya butemu, butujju, sikuwuliriza nsonga za ono yavumye empulira bubi, size ensonga z'alina okukola ki okuwuliriza. Tekyetaagisa kutwala budde bwa bannayuganda omulamuzi okusalawo ki ensonga eyo. So tuli bannakuwavu nnyo, twetondera nnyo bannayuganda betukosezza okutwala obudde bwabwe omulamuzi n'atuula wansi n'akola research n'asoma bye twawandiika ng'alina okugamba ekintu kimu nti kkooti ento mulindeeko paka nga mmaze okutunula mu nsonga zino, awo nja kubagamba ekyokuddako. Tujjukire nti nno twajja mu kkooti enkulu nga tugamba nti bye baali bakola mu kkooti ento byali bikyamu. Ne tusaba kkooti ento nti yimiriza paka nga kkooti enkulu ekoze eki, esazeewo ekunnyonnyole oba byokola bikyamu oba bituufu. Kkooti ento bwe yagaana ne tujja mu kkooti ki kkooti enkulu. Era tuli basanyufu nnyo nti kale kkooti esazeewo nti twali batuufu obwedda nti President Isaac Ssemakadde ensonga ze mu kkooti ento ziyimirire paka nga kkooti ekoze eki etunudde mu nsonga zino neraba oba bye bakola mu bituufu oba nedda. Era twagala nnyo okwebaza omulamuzi akoze ekikolwa eky'obuzira n'obuvumu okuyimirira n'agamba nedda, ensonga zino zirimu eggumba, okukwatibwa kwa President Isaac Ssemakadde, ebyokumuwozesa, ebyokumuyitaayita ku nsonga y'okuvuma omuntu ataze na mu kkooti kuloopa nti bamuvumye, bijja biyimirira paka nga ntunudde muki mu nsonga zino. So tumwebaza nti bino ekikolwa kya buvumu kyakoze, era President Isaac Ssemakadde era ataddewo etteeka eppya ku nsonga z'okuba nti nno obeera nga wemulugunyiza mu kkooti ento oze mu kkooti enkulu, kkooti ento erina okugenda maaso n'omusango oba erina okulinda bakama baayo kye banaagigamba. Ekyo President Ssemakadde akitaddewo, akibawadde bannayuganda ng'ekirabo, era aŋŋambye obubaka buno yeetondera nnyo abasibe abali mu makomera, yeetondera nnyo abantu abakoseddwa ebikolwa ebyekikolobero abatwaliddwako obudde bwabwe babadde balina okubeera mu maaso g'omulamuzi omulamuzi afokasinga okudetermininga ensonga entono ennyo eno ey'okuba nti nno ye president Isaac Ssemakadde balina okumuwozesa nga kooti ekyawuliriza okwemulugunya kwe oba birina okuyimirira. Era abeetondedde nnyo n'abagamba mukifune emitima gyammwe mumusonyiwe eri abasibe abali mu makomera ba victims abatuusiddwako obukolobero olw'obudde bwabatutteko obutwaliddwako omusango gwe kooti okuwandiika emiko 40 ku kasonga katono nti oba kooti eyimirize kooti ento eyimirire paka kooti enkulu ng'emaze okulaba ensonga zetuwaddeyo oba nedda. Era tusaba nti nno mumusonyiwe mumusonyire ddala.
Kale. Alright, bannange tufe ababitandika on social media yugi fa baleetera omusajja Isaac Ssemakadde. We moved with him buli kimu, so fa balina okubimaliriza. Era bulungi